or when an individual spends a holiday, say on a European cruise, when one watches television, or when one would watch, say, a weather forecast, when one is going to use internet. Like in all of these situations, there is a precept or a branch of international law that is involved. So when we talk about, say, a certain product being bought online from another country, we will see that there is an aspect of international trade law over there. When we talk about individuals spending a holiday somewhere outside, there is an aspect of international economic law. And also, if you are on a cruise outside, there could be an aspect of law of seas. And when we talk about when one watches television, so there can be an aspect of international direct television law. And when we talk about when one engages with weather forecast, so in that situation, you can see that there could be an aspect of undersea cables and submarine cables and satellite communications. So all of this, this entire expanse of international law, like while it often remains unobserved, understudied, and undervalued, it is generally the case with people who do not read enough about it, or who would not engage with such discussions. So now we're going to look into what are certain definitions of international law, and then we'll get on to like public international law from there. So uh, like the first one, which is very important for us. So like what exactly is international law? So what is important whenever we discuss a definition in any subject? So we have to be wary of the fact that definitions, they are going to confine, uh, limit, and also somewhat restrict the expanse of any field of study. You can pick up any subject matter, and that is what a definition does. So to define international law is also going to be difficult, as it would limit its meaning, the scope of actors which are going to be involved in this, what are the subject and the elements in that definition. So any definition to be widely accepted in any discipline would require that these are the things which are constant, or which remain constant over the period of time. Obviously, like you can have multiple definitions, but there has to be certain consensus there. So now it's very difficult to find like an accurate definition, or like a best definition of international law, and it's becoming pretty much a rarity to actually come across something that like everyone agrees upon. So the term international law was coined by Jeremy Bentham in 1780. Does anyone, like, have you guys studied, anyone in the class, have you guys already covered jurisprudence?
Yes, sir.
Professor, we are having it this sem along with PIL.
Oh, okay. All right.
They
So,
covered a little bit of Bentham, little bit, not much.
okay. All right. So that's good then. So then just anyone like who must have read about Bentham. So what has Bentham said? Like he's an English jurist, and what is his work known about? Anyone?
So Bentham came up with a theory of utilitarianism. Basically, he says all acts that need to be done have to be done
Mm,
for gaining more pleasure in society. Basically,
mm,
so anything which is pleasurable is considered a moral act, and anything which is not pleasurable is considered to, or immoral act is considered to be pain. Basically, so the job is to
yeah,
maximize pleasure and minimize pain in the society.
yeah, correct, Varun. So Bentham, being an English jurist, uh, he's also referred to as the father of utilitarianism, and and as you said, his like work is primarily around the moral theory, or what should be considered as right or wrong, and to what extent does it work towards human well-being or utility. So that is what the work is around. But Bentham was also someone who actually coined the term international law in 1780. So Bentham, in his work, which was Introductions to the Principles of Morals and Legislation, he defined international law as a collection of rules governing relations between states. All right. So, since traditionally international law operated on states as its subject, international law was thereby defined accordingly as well. So, it was defined as a law between nations. Like when we talk about law between nations, we have to understand that there is a horizontal aspect of international law that we are considering, that it's a law between nations. And now, when we consider a horizontal aspect of international law, we are primarily overlooking the diverse application of international law as we know today, right? So, and it was also like, so it was referred as law between nations and also referred to as law of nations. So it primarily referred to the body of rules that would govern the conduct of the states from the times of peace to the times of conflict. All right. So now it's obvious that the jurisprudence concerning international law has also led to different scholars commenting on it differently. So Oppenheim, I don't know whether you've covered Oppenheim so far. So Oppenheim was one of the positivist scholars, and Oppenheim in his work. So his work is primarily known about like the positivist commentary on international law, and so according to Oppenheim, law of nations or international law is the name for the body of customary and conventional rules which are considered legally binding by civilized states in their relations with each other. You can see certain aspects of what was covered by Bentham, and there is an advancement to it. So you can see that this definition of international law primarily has three components, right? So the first one is that there are rules which are regulating relations between states. The second one that you can see is that states are regarding these rules as binding. And thirdly, that such rules are being derived from treaties. Now, like a question to all of you, do you think, like, and you have the definition right in front of you as well, do you think there is anything missing or wrong with this definition? Anyone have a go at it? Like, there can be multiple things. Yes, Varun.
I think in your previous slide, you had said that international law is considered to be very, it's considered to be very pervasive in nature. It influences the lives of every person. I think by just mentioning only states, he's kind of restricting it again because I think international law goes quite far. I know it also influences the life of common people as well. And that's a drawback to his definition.
Correct. So that is one of the things that the definition can be criticized upon. So considering just states as the only subjects of international law and not including certain other things, say international organizations and persons as its subjects, that is where you would see like the definition is failing to a certain extent. And anything else, anyone? There like one or two other things as well, like which can be commented upon. So can you think of anything else from the first definition? You can see like there is a refined version as well. So maybe that could be more of a hint. But from the first definition, what do you think? Like there is something which is missing from it. Anyone?
Professor, maybe the aspect that it only talks about civilized states. What does civilized states mean? So I'm
Yes,
just
correct.
guessing.
Yeah, like that is correct. Yes, Srishti. So like using the term civilized states in itself is severely criticized in international law or in any aspect of international politics now, because it's primarily reflective of this European construction of themselves as civilized and the non-Europeans as uncivilized, right? So like just coming out with the definition as well, when you say that, oh, this is considered legally binding by civilized states. What do you mean by civilized to begin with? And in their relations with each other. So anyone who is not being bound by international law, like at that time, and this definition came out by L. Oppenheim in early 1990s. So anyone who is not a member or is not being bound by international law, can we say that that state or those people are considered to be uncivilized? But this is the general reflective. There's something that was reflective of a lot of scholarship which actually came from that time. Uh, and then lastly, like I would say that the definition also talks about that a law of nations or international law is the name for the body of customary and conventional rules. So in this case, the definition mentions customs and conventional rules. Let's talk about, like, we can take that as treaties over here as the sources of international law rules, while it does not include general principles of law as one of the sources. So that is also something that has been missing from this definition. So you will see that the earlier definitions mentioned about the states being the subject of international law and did not mention anything about international law organizations and individuals, which, as a later development, were also recognized as the subjects of international law. So, majority of the older definitions were considered to be standard, restricted. Like they were considered to be standard, where there was a certain restriction on international law to the conducts of the states inter se. That, like, there was nothing more to the definition of international law than primarily talking about that it's going to be law of nations or law between nations. So that is where the entire premises was. Yes, Shrishti, I can see that you've raised your hand.
Uh, Professor, you mentioned in one of the criticisms that general principles of law is not mentioned in the definition.
Mhm.
So by
Yes.
that, do you mean the natural law also?
What do you mean by natural law?
Like natural principle of law by, I mean, that that is like accepted universally and people agree to it. Like basically
Mhm.
something that is considered immoral and which becomes the natural law. But for example, killing somebody is considered immoral, so it becomes
Mhm.
natural law that you should not kill somebody.
Yeah, so that is what is covered in general principles law, like principles
Okay.
such as equity, or in natural justice and so on. So like these are the principles which are going to be covered in general principles of law, but that is not part of the definition once again. So there is also this criticism that, okay, like this thing is missing from the definition and was missing from a lot of definitions which came around that time. So if you see Oppenheim's revised definition, which was worked on in late 1990s. I guess like the book came out in 1996, if I'm not wrong, which was worked on by two scholars, just updating and editing the work of L. Oppenheim. And they came out with the definition that international law is the body of rules which are legally binding on states in their intercourse with each other. These rules are primarily those which govern the relations of states, but states are not the only subject of international law. International law organizations, and to some extent also individuals, may be subject of rights conferred and duties imposed by international law. So this is the revised definition, but this is also something which has been debated upon by other jurists. So then we will see that J.G. Stark is another jurist which talks about international law in his work. So, like J.D. Stark has also given us something interesting to observe. So, Stark defines international law as that body of law which is composed for its greater part of the principles and rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relations with each other, and which also includes, firstly, the rules relating to the functioning of international organizations and international institutions. their relation with each other and their relations with state and individuals, and then certain rules and law relating to individuals and non-state entities, so far as the rights and duties of such individuals and non-state entities are concern of the international community. So, if I have to break it down, then you will see that this definition tries as far as possible to incorporate the newly evolved subjects of law. So you have not just like the states inter se, but you have international organizations and individuals, which are other than the states, as the primary subject of international law. But this definition also has certain limitations to it. So you will see that the definition over here mentions about that in the second point, that certain rules and laws relating to individuals and non-state entities, so far as the rights and duties of such individuals and non-state entities are concern of the other international community. Now, like the entities, like there is this mention of entities having rights and duties as subjects of international law. Those entities whose rights and duties under international law have not been mentioned will, as per Stark's definition, fail to be considered as subjects of international law. And that is where the first, like one of the criticisms comes in. So, and then we have George as one of the jurists as well. So, as per George Schwarzenegger, like I might have butchered the surname. So defines international law as the body of legal rules. Yes, Warren. Sorry. Yeah, you've raised your hand.
Could you explain the drawback in the second point in the definition given by like the previous one, J.G. Stark? Could you go back to the previous
Yes.
slide?
Yeah, sure. Yeah. So the criticism with respect to J.D. Stark's definition of international law is with respect to the second pointer. So over here in the second point talks about that in the definition, the entities should be having certain rights and duties as subjects of international law. But what about those entities who don't have any rights and duties? It's not like rights or duties, but what about those entities whose rights or duties under international law have not been given anywhere? Now, like, will those entities be considered, not be considered as subjects of international law? So, like, when we talk about certain international organizations or NGOs, so like, what are their rights and duties? And have they been mentioned anywhere under international law? Does that mean they're not subjects of international law? So that is where there is a gap in the definition of J.G. Stark as well. Yeah, so we were on George. So George mentions or defines international law as the body of legal rules which apply between sovereign states and such other entities as having been granted international law personality. So as you can see, like from his definition, international law, interestingly, has been divided into two aspects. So first, it keeps the determination of subjects of international law open, and the term other entities can include international organizations, can include individuals, and any other entity in the future, which then is classified as a subject of international law. And secondly, the qualification of a subject as a subject by the legal personality. So when he says that body of legal rules which apply between sovereign states and such other entities as having been granted international law personality. So when we talk about like granted legal personality, so it possesses under international law a safe option in defining international law. So it is somewhat of a safer option. So uh, at last, what I wanted you to understand from all these different definitions is that international law addresses diverse and pressing issues which are happening in international politics and are affecting the global order. It deals with the proliferation of international organizations. And also, it somewhat provides an embrace to new subfields which emerge from public international law, right? So even the transition, which we have seen from states as the only subject of international law to the addition of international organizations and individuals as its subject, has been somewhat remarkable. So this has led to an addition to the variety of sources from which international law rules can actually be derived. Because we have seen that when we discuss the definition, say starting from Bentham, then we moved on to Oppenheim, and then we looked into like what was the definition given by J.D. Stark. So we will see that there is a constant upgrade on the understanding of what are the subjects of international law, and like what all, like obviously what all is going to be covered by international law, the subjects, and also the sources, what can be the sources of international law. So over here, like although we do rely on definitions for our personal clarity and any coherence that we might want to derive for analysis of any subject or any discipline for that matter, this is something that we need to keep in mind, that finding a definition of a subject which has such distinctive features and a subject which is constantly evolving has always been difficult. And that's why, like, if we take another subject as an example, say if we take environmental law as an example, it's very difficult to actually explain what exactly is environmental law and what is covered by environmental law. So there is one interesting definition to environmental law, which also says that it is a planetary law of housekeeping. So it pretty much includes everything which is there on the planet. So it's a similar case with international law as well, that it's got like distinctive features and it's constantly evolving. That's why like coming down to one definition becomes like it becomes quite difficult. So any new events which happen across the world and any establishments that like that happen across the world can be continued to challenge, and this might result into establishment of new principles of international law, or can lead to devise a definition that might reflect these newer dimensions which would demand erudition once again. So, to finding a definition closest to the true character of international law, uh, it's always it's always an endeavor of every international law scholar who's working on a certain type of scholarship, right? So, uh, and as third year law students as well, you will see that you must be aware that state laws operate in a well-defined hierarchical political society, right? So the laws which are going to be formulated by state, and this is where I come down to horizontal nature of international law and how that is different from state law or municipal law. So we'll see that the laws which are generally formulated by state legislatures are ensured by a certain vertical authority that individuals have to follow, right? So there's someone at like the lowest level of hierarchy, then there is someone above that, and then like the entire vertical structure works whenever we talk about power or any vertical authority that any individual has to follow under municipal law. Meanwhile, you will see in the case of international law, you will witness that the political society lacks such hierarchy, and every state is treated equally. So international law operates as what they say, jus inter partes. So jus inter partes is a law that governs relations between subjects horizontally and not as jus super partes. So jus inter partes is where the law is going to be governed between subjects horizontally, and jus super partes is when the law is governed from above. So there is a difference between the two. So from the point of view of a state, an authority superior to the authority of the states is inconceivable in an international legal system. So, because when we talk about sovereignty, there is nothing above the state in that case. So, whenever we, yes, Shrishti.
Professor, the terms that you just mentioned, could you please like type it in the chat box because like it's not on the slide, so we can at least make a
Oh,
note of
yeah,
it.
sure, sure, sure. Yeah.
Thank you, Professor.
So it's jus inter partes.
With the meaning.
Oh, okay. Just explaining the meaning.
Yeah.
Uh, So yeah, like I've mentioned both of them. So just inter partes is the one where law is governed, law primarily governs the relations between the subjects at a horizontal level. That's the first one, inter partes. And super partes is wherein the law is going to be governed from above. There is a hierarchy which exists. So international law operates with respect to the first one. Once again, coming down to the horizontal nature of international law and how it operates. And municipal law generally would be governed with the help of like the Latin maxim "jus super partes," wherein like the law is going to be governed from above. So as I mentioned that, and also why this is important, that in an international legal system, operating with just super parties is almost inconceivable because no state is going to admit that some other state or a foreign body is actually governing them from above because state sovereignty is supreme in that case, right? So, wherein if you look at primitive societies, you will see that the hierarchy as well as the authority was always vertical in nature, while on the other hand, now what we see is with the help of like the the doctrine of sovereignty which has come in, we talk about that international system is horizontal in nature. And interestingly, I'll cover like when I'm covering history of international law, I'll use the example of sovereignty only because it'll be easier for you guys to understand too. So otherwise, history of international law in itself is a very diverse topic because you have various scholars. Hmm. Yeah, so you have various scholars who are talking about like how the history of international law has been missing certain aspects from it because it has been written from a very Eurocentric point of view. So I'll come down to that. Like I'll touch upon sovereignty once again, but I thought like it's like a good example and an easy example as well to actually understand the relationship between international law and municipal law. So you will see that, as I mentioned, that in most primitive societies, the hierarchy was always vertical in nature, whereas in rational system, it is somewhat horizontal. So this understanding also accounts for the horizontal and heterogeneous developments that have happened in international law. So you'll see that growths in certain specialized fields of international law have happened simultaneously, which can either complement or conflict with each other. Or if we look into the establishment of various courts and tribunals which run parallel to each other, and the proliferation of new subfields of international law have led to this perceived damage or the coherence of the international legal system. So, what do I mean by that? Just to give you an example, right? So, obviously, we have seen that this horizontal and heterogeneous developments of international law has happened in, say, last one, you can say now, 1 century. Yeah. So, 1 century would be a good field wherein you would see like a lot of specialized fields of international law have actually come up. So, and how establishment of various courts and tribunals running parallel to each other can actually complement each other and at times can be a conflicting with each other as well. So let's take an example of WTO as World Trade Organization. So World Trade Organization in its preamble talks about principles of market access and non-discrimination. And also in its preamble, it talks about protection of the environment. Now, like when trade happens with respect to certain plants and animal goods, that is where concerns around environment also prop in, and that is something that we have seen in numerous international law cases which have been brought before the dispute settlement body of World Trade Organization. There is generally an argument which comes in that whether World Trade Organization is the correct body to actually address these issues or not, or is there somewhere else we should actually be going. So while it can complement, and it has done that, so in certain cases, so you have shrimp turtle case, you have US tuna case, and numerous other cases wherein like the dispute settlement body of the WTO has given certain findings which were in the favor to actually protect the environment. But then in certain instances as well, you will see that they will completely move away from the responsibility. They say like this is not the subject matter of the World Trade Organization, and maybe there is some other tribunal out there that you should be addressing this matter to, right? So, and similarly, when we talk about international trade, there are also matters which can come in with respect to working conditions, right? And I don't know, like how many of you remember this, but Trump, when he was blocking appointments to the appellate body of the WTO, he pointed out that how like China has been dominating the international trade because the WTO is not considering like the working environment, the minimum wage, which should be considered when we are talking about free and fair trade. So, but WTO once again said like that is not the subject matter which the WTO has to deal with. That is something that ILO would actually look into, not us. So you would see that somewhere they complement, somewhere there is a conflict as well. So the specialized regimes and different dispute settlement mechanisms and even other heterogeneous and uneven developments in the normative and institutional framework of international law refer to this phenomena which is known as fragmentation of international law. So this is something that I thought like might be interesting. So like coming back to what we were discussing, so just to simply put it, international law, unlike municipal or domestic laws, is generally concerned with the states of the world community, which can either be geographically small or large. Uh, it could be politically strong or politically weak, and even ideologically democratic, or can have certain aspects of like authoritarianism. So state law will regulate the behavior of the individuals, whilst international law attempts at regulating the behavior of the states. And to attempt that, when we talk about regulating the behavior of the states, that in itself is not an easy task. Because states are pretty much like, while we say like they are pretty much the building blocks of international law, at the same time, they're sovereign entities which are unrestrained by any external political power. So, to direct or even talk about regulating a state's behavior is easier said than done, right? So, you can't say, ki, oh, like we'll be able to regulate or direct a certain state's behavior. So, that's why you would see like ICJ, when we talk about jurisdiction, it's mostly like the opinions which come out are also advisory in nature, right? So, you can't like regulate a state's behavior, so it's very difficult. So then we try and look into public international law versus private international law, and this I think is something which shall be dealt in the first class itself. Because it can be confusing, and this is something that I've come across. I've seen students often getting confused between public international law and so-called private international law, because public international law or international law refers to the body of law providing for the rights, duties, and governing the relationship between states. Whilst private international law or conflict of laws, um, which like has a very misleading designation to it, is actually an area of national law. Okay, so private international law would refer to cases within particular legal systems. Yes, Shrishti, sorry, like yeah. Got a question?
Professor, sorry, but I did not really understand the fragmentation of international law part.
Or the fragmentation part?
Yeah, I didn't understand that.
Okay, all right. So when I was discussing about the fragmentation of international law, I was trying to gauge your attention towards that how there are specialized regimes. There can be different dispute settlement mechanisms and even uneven developments which are going to happen in different specialized fields of international law. And all of that is going to happen simultaneously. So that in itself leads to fragmentation of international law. So like the international law, what we see is not something which is going to only have a heterogeneous and horizontal development, right? So we can see that all like states, initially only states were subjects, then we add international organizations and individuals as subjects as well. Sources of international law came up, and it was like sources of international law also developed over the period of time. But the fragmentation happens when we see that various specialized fields of international law have taken their own complementary or conflicting routes to each other. And that is where fragmentation happens. Is that clear?
So, Professor, for an example, can we say that the international bodies such as ICJ, ICC, all
Mhm.
of these exist, and like UN, all of these exist as dispute resolution organizations, and they have their conflicting as well as you said yeah, so they have their conflicting and complementing contributions. I mean, is that a proper example for fragmentation?
Yes, so you can pick up any court or tribunal which is running parallel to each other, or any subfield of international law which is basically developing over the period of time. So everything is leading to fragmentation of international law. So it's prime, like the basic idea is that any development which is happening, which we initially saw that, or like it is happening at a horizontal and heterogeneous, in a heterogeneous manner, that is no longer the case, because every institution, every tribunal is working with their own principles, which is leading to further fragmentation of international law. There's so much that is impossible to cover. And this is something which you will understand once you go on reading about public international law in this course as well, that there is so much fragmentation that you are only covering just the mere basics of public international law. You're not even going into 10% what is there when we talk about public international law. So you're just covering the things over the top. Then you get to decide when, like, you start working as lawyers, if you end up working on the international, if you start working as an international law attorney or something, that you will choose a certain field, a certain specialized field, and then you will see that, oh, like there's so much fragmentation because there can be so many conventions, decisions which can point towards a different understanding of the same term. So that is where the fragmentation is happening over the period of time.
Got it, Professor. So,
Yeah.
can you just tell me if my example was also right?
Yeah, it was. Yeah, like you've basically taken examples of ICJ, which is a court, and then like if you pick up like any other tribunal or any other form which is leading to a development. So everyone is taking their own trajectory.
Okay, Professor. Thank you.
Yeah. So we were discussing public international law versus private international law, right? So yeah. So as I mentioned, that public international law or international law is going to be referring to a body of law which provides for the rights, duties, and the governing relationship between various states and other subjects. While private international law or conflict of laws, that is what private international law is also known as, conflict of laws. So it's somewhat a misleading designation because it's actually an area of national law. So private international law would refer to cases within particular legal systems that entail a foreign element to them, and thereby raises the question of applicability of foreign law, whether there would be an applicability of foreign law to it or not. Let's take an example of conflict of laws. So let's presume that an English person and a French person enter into a contract for the sale of property in France. Now, the question is going to be around the applicability of English or French law by the English or French code wherever the case is instituted. So now this is a question of conflict of laws, which is private international law. And like, let's take another example. So like if we look into the application, say pick up any country, like their traffic laws by their court in a case involving injuries of another foreign national or of a foreign tourist by that court. That once again, like what law are you going to apply in that case, and how will you actually determine the compensation? That will also depend upon like uh, like the entire thing would depend upon the conflict of laws. So it is an area of national law, while public international law primarily deals with the rights, duties, and relationships of the states. Private international law, on the contrary, would deal with the rights of the individuals of different nationalities. So, private international law is primarily, or you can say like essentially, a conflict in various national laws to approach a certain question of law. So, I would say like an easy way to remember would be that private international law, like let's begin with this thing, has a misleading designation and is in a sense a part of domestic sphere of the states or domestic, like the question that you're addressing over here is more around the area of national law, and it is a conflict of law. So many scholars are of the view that it is proper to refer to private international law as conflict of laws rather than private international law. And another way that you will see, like, and if you look into the subjects of international law, on the contrary, so you would see that subjects of international law, as we saw from the definitions, they're primarily states. All right. So with you would see the establishment of various international organizations and separate legal personality which was bestowed upon them, and the international organizations were also being treated as subjects of international law. So you will see that this is something which has happened over the period of time, as we saw from the definitions as well. So it's not states inter se. Now we have international organizations which developed over the period of time, and we gave them separate legal personality. And also, when we talk about persons being like your being subjects of international law, public international law, then we see that in cases of human rights violations, or when it comes to refugee issues, even individuals are considered to be the subjects of international law. So the subjects of public international law are like first states. So states are considered to be the primary units of international legal order because states have rights and duties under international law. Okay. The second is international organizations. So during like when we saw the initial phase of development of international law, it primarily dealt with the conduct of interstate relationship, as I said, states inter se. So international law was perceived initially as a law or a body of rules to govern the relationship between the states of the world. The states were the primary subjects of international law. And it was only later on, with the establishment of international organizations, as we see with League of Nations, the United Nations, World Trade Organization, ILO, uh, uh, IBRD, World Bank, and so on, they were also recognized as subjects of international law, right? And then lastly, we have individuals. So when it comes to concerns which emanate from human rights discourse, it does include individuals. And like, albeit it can be in a different and limited way, but you would see that international covenants and conventions relating to human rights bring individuals under the purview of international law. So interestingly, if anyone knows anything about Nuremberg trials, so it was well established that international law may impose restrictions on directly on the individuals. And you would see both from Nuremberg trials and Rwanda trials that individuals were tried for their criminal liability. It wasn't the state, it was the individuals who were tried under international law. So once again, individuals are also subjects of public international law, right? So that is where we are with respect to public international law versus private international law. Once again, like someone has raised their hand. Yes, Palak, and then I'll come to Rishita.
Actually, sir, this is the doubt regarding the example that you gave about uh, WTO, that there was
Mhm,
trade happening with respect to plants and animals and all. The
mhm,
argument that you gave that whether WTO was correct body to address the issues of environmental law, what was the
mhm.
aftermath of that argument? Like, what happened exactly after that? Were there new specialized, fragments of international law introduced?
Yeah, so interesting question. So just to expand upon that, Palak, so there have been multiple cases before World Trade Organizations, which talk about international trade, which can affect environment to a certain extent. And like World Trade Organization, to a great extent, has actually given their decisions on it. So you have various panel reports and appellate body reports on it, but generally there are scholars which believe, and generally international law scholars, which are not dealing with international economic law. They do believe that this shouldn't be the subject matter of World Trade Organization. They should be more concerned about international trade happening rather than addressing environmental law matters. So that is where there is a different discourse. You would have like a different there's one of the criticisms that WTO generally gets, that they are trying to get into something that they weren't created for. So even though they might be doing good work, and the only reference which is there about their need or their aim to protect the environment, that is mentioned under the preamble. Everywhere else, you will see like there are general exceptions being present under GATS, and a lot of other agreements. But generally, like it said, that that was not the purpose of why WTO was created. So why is WTO actually giving decisions on environmental law concerns as well?
All right, Professor.
Yes, Rishita.
So, Professor, as much as I know in international law, the concept of individuals are not regarded as legal persons in international law, right? So
Mhm,
they're linked by a sense of nationality. So the ICJ sort of caters to the factor of a nationality. Now, as you said, you were speaking about the Nuremberg trial and the Rwanda trial.
mhm.
I fail to understand how exactly this enforceability works when it comes to individuals, or more specifically, when it's tied to a concept of a genocide and individuals committing the genocide. So, enforceability of international law with respect to individuals is something that still confused about.
Yeah, Rishita, with respect to that, like I'm afraid like you'll have to wait, because that in itself would lead us to a different direction. And that is something that I'll be covering in the later modules. But when I was talking about individuals as a subject of international law, I did mention that like individuals are referred to as one of the subjects of international law, albeit in a different and limited way. So that is where the limited way comes in. And as you rightly pointed out, that it's usually in the matters when we talk about human rights violations or genocides, that you're not taking them, like the entire subject matter is very limited in nature. Like in on what grounds are you actually targeting certain individuals, and how is the trial being carried out? So that is something that I'll try and cover like in the later on modules, because that will steer us away from just the very basics for now.
All right, thank you, Professor.
Yeah. Any other questions with respect to this? Okay, all right. So we'll do one thing. we'll take a short break of say like 5-10 minutes, and then I'll go on to history of international law. I don't really have slides for it for now, but then I'll share like the slides with you later on. It's more of a story format that I'll take, and that is how we'll proceed with it. And I'll try and cover, because it can actually take more than one class. So I'll try and address some parts of it today, and then the remaining parts we'll try and cover in the next media lecture. But if you are actually interested in international politics, or just the history of colonization, decolonization, or global South scholarship, like I would say like history of international law is one of the most interesting parts, which is there in public international law. So we'll just take a short break. We'll come back by say 12:25. Let's do 12:25 then. All right, class. So I'll go to history of international law. I've just like quickly added like a couple of pointers that I'll try and cover in another half an hour. We'll see like how much we can cover. Otherwise, we'll cover that in the next remedial class. I'll try and cover like the history of, complete the history of international law in just one class. I'll try and aim for that. Like in the next class, we are able to complete that. So history of international law in itself, as I said, is quite expansive, quite extensive, and you will have like various scholars writing proper books around it. So, and that too from their own perspective. So you can write it from a third world perspective. You can write it with respect to history of international economic law, law of seas, and various other subfields as well. Like you can pick up any subfield and you will see that how the history of the evolution of international law has been dealt with. But for today's class, and this is something that I think is going to be very important for us as well, like to actually focus on, is to look into the colonial and the post-colonial aspects of international law. Given that we're a country in global south, it makes very important for us to actually understand the global south perspectives, the issues, and have an understanding of international law from a global south perspective. So, what we have to understand over here is that colonialism is one of the major concerns of this discipline and is basically central to our understanding of the formation of international law, which includes its founding concept as well as sovereignty, right? So, our traditional understanding of international law would regard colonialism and indeed any non-European society and their practices more generally as somewhat peripheral to this discipline, because international law was actually a creation of Europe. There is no denying that. So the explicit and unquestionable European character of international law has been very powerfully and asserted by various historians of this discipline. So, international law has been seen as, and it has been commented upon as, that there is one truth that is not open to any denial or even to doubt, that the actual body of international law, as per the historians, I'm saying, people who were writing on international law initially, that they said that that it is the product of the conscious activity of the European mind, but also has drawn its essence from common source of beliefs, and it's mainly of Western European origin. So that was the initial understanding of international law. So international law, with such a view, with this very traditional view, consists of a series of doctrines and principles that were developed in Europe and that emerged out of European history and experience that were then extended to the non-European world, which existed outside the realm of European international law, right? So, as I mentioned that I'll try and bring in a very simple concept of sovereignty, right? And we'll try and understand this entire discourse from the example of sovereignty, because that is one of the fundamental principles of international law. So we'll try and address this history aspect with the help of sovereignty. So it helps me limit down like the argument that I want to take as well and the lens that I want to take. So I can show you that how we need to understand the development or the evolution of international law since we are in a global south country. So, so the classic concept of sovereignty, like which came about from the Treaty of Westphalia in 1648. So it talked about that how all sovereigns are going to be equal, and sovereign states have absolute power over their own territory, right? So non-European states were believed, and we're talking about Treaty of Westphalia of 1648, right? So by 1648, you will see that most of the countries which are part of the global south now, like they were colonized. So non-European states lacked this sovereignty that is being discussed. And the development of international law then can be seen as an expansion of international society, and the process by which this idea of Westphalian sovereignty was then extended to include the societies of non-European world as well. So this entire process was completed through the mechanism of decolonization that ensured that there would be emergence of certain sovereign states and from what had previously been the colonized societies of Asia, Africa, and Americas, right? So in this way, when you look at it, so colonization was an unfortunate, but like if you look at it from a very Eurocentric perspective, it was unfortunate, but perhaps necessary historical episode. So whose effects have been largely reversed by the role that international law has played. So would see the mention of like non-European world being referred to us from earlier texts. If you look at texts of international law from 16th century, there is a mention of obviously like the nature of civilized, uncivilized, and like even savages, barbaric system existing outside Europe. So yeah, so when we look at it like from a very Eurocentric lens, so we see that, oh, colonization was, although unfortunate, but was necessary historical episode. And it basically played a huge role, international law played a huge role, like particularly through United Nations system in promotion of decolonization by both institutional and doctrinal mechanisms. So whatever you will see that like there were earlier associations of imperialism and international law. So that imperialism is said to be a thing of the past. Although, like when I come towards the end of this history of international law, like I'll point towards that how there is an argument made that like the imperialism still exists. We are in a state of new colonialism. So I'll come to that. So another problematic like thought which exists or existed between the international law scholars was around that how the traditional understandings of the relationship between colonialism and international law emerged in the 19th century with the help of certain scholars like John Austin, right? So have you guys covered Austin in the class in jurisprudence so far?
Yes.
Oh, you have. All right. So can anyone tell me like what, according to Austin, is law? Just very simple understanding of Austin's work would do. Yes, Varun.
He propounded the command theory which says that whatever law is laid by the sovereign, that's basically law that
Mhm.
subjects to the state must follow.
Correct. So according to Austin, who was an English jurist, as per him, law is the command of the sovereign, right? So he argued that law and order were only they were basically inexplicable in a system which is going to be governed by an overarching sovereign that could create and enforce the law. So, like out of that, consequently, international law could not be regarded as law properly, so-called, since the international law system lacked such sovereign. So this problem emerged pretty much corollary to the Westphalian model of sovereignty, which stipulated the equality of sovereign states. So since that time, at least the question has always been around that how is the legal order to be established amongst equal and sovereign states? And also like one of the greatest scholars of international law have various scholars of international law, they developed this theory that questioning the Austinian paradigm, and that on how we can actually elaborate on international law, and how it is a law despite the absence of overarching sovereign that legislates and then enforces the law. So there are a lot of questions around this as well. So and also there were the non-European world also posed numerous problems to the international system around that time. Because when we talk about law is the command of the sovereign, right? That is a positivist legal thought. Then, like, how were the people in the non-European world, like how should they be governed when we talk about colonization, right? And on what legal basis could their lands be occupied? Like, what exactly are we talking about? Like, if there is no sovereign, on what legal basis are we saying that their lands could be occupied by like the European powers? And then these were basically the practical and secondary problems, but they still, like, as comfortably as they do, they did not impinge on like the theoretical issues. So they went ahead with it, they justified it by using international law. So that is something that we will cover. So international law, we will see that how it was seen as an attempt to establish a universal system of order among entities which were categorized, even though belonging to a different cultural system. And there was a difference between European and non-European cultures, and how they were brought together, like under the under international law, and how colonialism helped under the same thing as well. So so when we talk about, let's go into, so this was just like a brief outlook. So it must have been like really confusing, but I'll just expand upon that now. So let's start with the colonial origin of international law, right? So contact between your European and so your contact between European and non-European world. So when we talk about that, we'll see that it has taken place for many centuries, right? So there has been European presence in non-European areas, which got intensified in 15th and 16th century with the help of international trade. So now, just to justify like colonization, we see like how things were happening then. So in 15th and 16th century, then legal doctrines were developed to manage more complex forms of interaction between European and non-European states. And this was extended inevitably to doctrines that helped in acquisition of sovereignty over non-European people. So, like, what are these doctrines that I'm talking about? So, these doctrines were created by Europeans, or they were adopted by Europeans for their own purposes. Although scholarship, like over the period of time, has shown that many important international legal principles relating to, say, the law of treaties or the law of war were also developed, understood, and practiced by non-European states. But many of these themes, you can see from like the work which has come from the first text of modern international law from Francisco de Vitoria. So Francisco de Vitoria was like a Spanish jurist and also a philosopher. And his book on the Indians lately discovered, that's the name of the book, on the Indians lately discovered. He talked about these complex legal problems that primarily arose from Spanish claims uh, to sovereignty over the Americas following the Columbus's voyage. So, so what Vittoria actually talks about, Vittoria actually talks about is this like very naturalist and theological jurisprudence. Because he's a philosopher and he was also associated with the church at that time. So he argued, like Vittoria argued, that all people, including the Indians, and Indians over here, we are talking about like the Native Americans. So all Indians all people, including the Indians, they are going to be governed by a basic natural law. All right. So the basic natural law dictates that everyone would be given similar rights. Now, but the interesting part is, like while others characterized Indians as heathens and animals lacking any cognizable rights, Victoria instead humanly asserts of the Indians as they are not of unsound mind, but have, according to their kind, the use of reason and so on. So, right, so it is because of his acknowledgement of humanity of the Indians. Of the New World that Victoria was remembered as a champion of the rights of indigenous and non-European people. Although, like I'll come down to like how it is quite messed up as well when Victoria goes further into like his expansion in his book on the Indians lately discovered, wherein he's talking about these complex legal problems which were arising from Spanish claims to sovereignty over Americas. So then in that case he like talks about that there is a possibility that while there is an order apparent in Indian affairs, it is nothing but a deficient order because it fails to meet the universal criteria which is established by natural law. So as per Victoria, whatever was considered to be the natural law, there was existing order in amongst the Indians, but like it was not up to the par as to what was considered to be the universal criteria by Victoria. So as a consequence of this, Victoria suggested that there should be proper government which must be established over the Indians by the Spanish. So you will see that like this is how colonization starts, right? So they make an argument that all right, like especially the scholars, they're not going to make a straightaway argument that all right, like Indians are heathens or animals or they lack any cognizable rights, they are savages. No, but the argument starts that all like there is a need for a proper government which must be established over so and so society in the non-European world by the European by the European people because like the so-called people are uncivilized. So the Indians now were regarded as children in need of a guardian. So they come over as guardian, and then it goes on to that how can there is a need for a remedy. Like there is a need for remedification of the society, which can do with more civilized way of governance. So, so now what would that require? It requires an intervention. And in this case, Victoria said, like there is a need for intervention of the Spanish, who are categorized as the agents of natural law. So that is where we are. This is how it starts everywhere across the world. So the ramifications of any asymmetries which the Victoria pointed out. So then he said that in order to enunciate or to go ahead with the principles of natural law, the Spaniards should have a right to travel to the lands of Indians and to sojourn there so long as they do no harm and they cannot be prevented by the Indians. So these apparent innocuous rights to trade and travel have profound consequences because then they say that all right, like to keep certain people out of the city or province as being enemies or to expel them when they're already there uh, are basically acts of war. So like now that you've entered the city and you're trying to do something for them, if you go against them, like or if you treat them as enemies, then you have the right to expel such people or such regimes, and it can be classified as acts of war as well under natural law. So or under the principles of natural law. So does any resistance like let's take Indian resistance to Spanish incursions would amount to an act of aggression by the Indians that would be justified by the Spanish in using force in self-defense. And this is what you'll see. Like this happens even now. Like that's why like the argument of neocolonialism and why imperialist powers still exist. They've just taken a different way of using international law. But you will see that this is generally what happens. That if you think that the other state is not uh, going ahead with what you consider to be like one of the principles of natural law or any principle that you think is the correct way of governance, then you can actually go against them, and that would amount to an act of aggression, and that can be justified by using force and self-defense. How much force is to be used? No one knows that. And in so doing, in endlessly expanding their territory, and then you can conquer the native rulers in this process as well. And then violence arises as per the Vittoria system as well, and this will inevitably lead to violation by the Indians of the natural law by which they should be bound. So once the war is commenced, as per Victoria's scheme as well, which is basically the scheme of Europeans, right? So, like it will have an overwhelming and transformative character in itself. So, it is through war that any Indian identity might be completely, uh, might be effaced. So it is thereby clear that war against the barbaric Indians has a different character from war waged against a civilized Christian adversary, right? So, and once again, like when Victoria talks about this war, he reverts to principles of arguments in the times of crusades. So basically, you're taking the argument that, all right, like this is nothing but a crusade against the barbaric Indians, which exist beyond the existing rules of law. And war against Indians is nothing but perpetual. So thus, you take both the protection of law as well as any outside protection that you can take. In this case, you're basically taking the examples of crusades and why it is important. So, Vittoria's work primarily demonstrates that, like, even though the centrality of commerce to international law exist, we see that how, with the help of commercial exploitation, we can lead to war. And this is something that we've seen, especially when a large part of America, Africa, and Asia was being colonized. Similar arguments were taken all across the world. And we will see that non-European world was categorized as someone like who is like they comprise of individuals who are anxious to trade with the Europeans. They're oppressed by their own rulers, and they're looking for the Europeans to liberate them. And they are backward, they are in need of guidance, and then they are irredeemably and hopelessly savage and violent in nature. And they need this European intervention, and this would be the appropriate response because the European intervention or European violence is categorized as it's going to be categorized as something which is liberating, transforming, and humanitarian. And this, like, you will see similar arguments being taken around, like when a lot of global North countries they enter into wars in other global South countries, taking these arguments that, all right, like we're going to liberate so and so society, we're going to transform it, and we're going to make sure that this humanitarian crisis is removed. Although, like we've seen that, in especially in the case of Middle East, that the war continues for different reasons. So yeah, so it's something which perpetuates over the period of time. So I think I'll stop over here for now because I'll try and go into the positivism argument in the next lecture. Yeah, because that in itself would lead me to terra nullius and so on. So any questions so far? All right, okay. So I think we'll end today's class over here. And I'll see you all. I'll talk to your CRs and figure out like when can we possibly have the next remedial lecture. The aim is basically to make sure that I'm able to cover just the introduction to international law and sources of international law, and then we'll get on with the regular lectures because I want to take the presentations as well simultaneously because that's part of the internal assessment. So I just want to provide like a good background to you guys. And if you do have any questions, you're more than welcome to ask. And there's anything, and also like just as a note, there would be certain things being covered in the class from a very high level perspective. But if you think that, all right, we can do with like further insight into it, then more than happy to take like an online class, just touch upon like further things in relation to it. So that can always be done. But given the nature of the course and how much it tries to cover, and that too from a very high level perspective, then I think like we'll always fall short of time in this course. And we might not be able to cover everything that I would like to cover or you would like to cover. But yeah, like we can always use like online lectures. So yeah, just to cover like anything additional which might be there. All right. Okay. So I think that's about it. And have a good weekend, guys. I'll see you all in the next class whenever it is scheduled.
Thank you, Professor.
Thank you,
Thank you, sir.
Professor.
Thank you, Professor.